In this training module, I'm going to explain the three types of patents available in the United States and where provisional patents fit in. This includes providing an introduction to utility, design, and plant patents, as well as diving deeper into the distinctions between provisional and non-provisional patent applications within the utility category. By the end of this training module, you should be able to see the value of different types of patent applications, understand which type is right for your invention, and decide whether the provisional process is applicable to your innovation. Let's get started. The most prominent type of patent application that's used in the United States is the utility patent. Utility patents are basically patents for inventions of useful structures or functions. In another training module, we talk about what is required to meet patent-eligible subject matter requirements, meaning what type of subject matter can be patented in a utility patent application. Essentially, these are useful structures or useful processes or functions, and they cover all of the hardware or the implementation that's carried out by the hardware in a device or in a system. Essentially, all of these need to be tied to technology in some way, shape, or form. Technology is used broadly here, meaning a system, a device, or some new type of physical feature or some type of data that interacts with or is manipulated by physical features. I don't want to overcomplicate this though. Really just think of it as you're inventing a new thing, or you're inventing a new process that affects the things around it. In essence, it needs to interact with the real world and with physical devices in some way, shape, or form. Utility patents have generally a 20-year protection period. This 20 years starts from the time that the patent application is filed, and so you can see that if a patent application takes several years to get through the examination process, it will impact the amount of time left over after the patent is issued, and the remaining time of that 20-year period will be the period in which the patent can be enforced. Now, of particular interest in this workshop is the distinction between non-provisional patent applications and provisional patent applications. And again, notice here that I'm talking about patent applications, not patents. The word patents would typically refer to issued patents that have already been through the examination process and been allowed and granted by the U.S. Patent and Trademark Office. In contrast, patent applications are the documents that you will be putting together, or a patent attorney will be putting together and filing so that it can be examined by a patent examiner. Think of provisional patent applications as the precursor or a placeholder for a later filed non-provisional patent application. Ultimately, non-provisional patent applications are the full application that have to meet all of the formal requirements that we talk about in other sections of this workshop. That's the application that will be examined and that will hopefully be granted as an issued patent after successful examination. A provisional patent application, in contrast, is really meant to be a placeholder. It buys you a 12-month period in which you can get your patent application on file with the Patent Office and get a filing date. The filing date is important because it allows you to save your place in line to show that you had filed your application prior to other people who might file an application on a similar invention after your filing date. This is very important now, especially because the laws in the United States are based on a first-to-file system, as opposed to what used to be a first-to-invent. First-to-file simply means the first person to put it on file with the Patent Office gets priority if there's a conflict. So provisional applications really just save your place in line. They get you a 12-month window so that you can then later on, if you decide to, file a non-provisional patent application on the same invention and pursue that with acknowledgement of your prior filing date. Most people will use the provisional patent application to get in quickly into the Patent Office because it has fewer formal requirements compared with the non-provisional patent application. Now, we're going to go through all of those requirements here in this workshop, and we're going to talk about which ones we should follow and which ones we might want to deviate from a little bit by either including more information or by being more particular in certain sections of the application that are either not required or aren't required in the detail that we're going to draft and file them in. So if you're just getting started in the process of patents, if you don't know whether or not you need to file a non-provisional patent application, if you don't know whether or not you have a product that you're planning to launch, you need to test the viability of the market, you want to test whether or not you can even get a patent, you want to do some more searching, either on the technical or the market side of your invention, a provisional patent application, when done correctly, is actually a very powerful tool. The second type of patents that are available in the United States are design patents. Design patents are specifically intended for ornamental design features. These contrast directly with the useful hardware or physical, tangible implementations of utility patents. Design features that have utility, in some instances, can actually be excluded from design patent qualifications. So design patents are limited to ornamental design features by themselves, without the utility functions that might accompany them. Design patents are much simpler to get usually because the patent examination process is a simpler process based on the drawings alone rather than an interpretation of claim language that you have to do in the examination of utility patent applications. Design patents also have a shorter term of protection. It's only 14 years instead of 20 years. Design patents also can be much simpler to enforce in certain circumstances and can be a lot faster and cheaper to enforce. So sometimes it's actually advisable for people who want to get a patent on a utility invention to also look and see if there's a possibility of getting a design patent on the design features of that same invention. You should note here that the provisional patent application process does not apply to design patents. You can't file a provisional patent application and then later claim priority back to that provisional patent application using a design patent application. That's simply because the provisional patent application is meant to cover the useful features and structures of the invention, compared with the design patent application, which will be claiming the ornamental design features of that invention. The next type, and the last type of patent applications available in the United States, are plant patents. And it's rather rare to see these in use unless you're dealing with a very agricultural type of inventor or company. Plant patents cover asexually reproduced plants, which means that you get coverage for discovering or creating a new type of asexually reproduced plant, as opposed to a plant that reproduces by itself through its own seeds. So these often are grafts and those types of things of plants that have been found or have been created through other processes and then are propagated or reproduced by continuing to graft them into other plants, into other stems. Plant patents, like utility patents, have a 20-year term of protection, and again, like design patents, cannot rely on the provisional patent application process to gain an earlier filing date and priority date. That's it. You should now be able to distinguish between utility, design, and plant patent rights and understand how to use the provisional patent applications in your innovation process.